Alex here with a legal nuts and bolts video on depositions. This is the fourth and last video in a series of 4 discovery videos. I urge you to watch the previous 3 videos and also, if you get a chance, watch my video on discovery because it covers the overarching general principle behind discovery, how it's used, some of the quirks, some of its limitations, when it happens, and all of that. So anyway, going straight into depositions. I have never done a deposition. Even though I represented myself a bunch of times, I've never done one of my own. There were a few times I kind of thought about it, but I ended up never needing to do it. I have been in a deposition once, and it wasn't really a big deal. It was basically like having court outside of the courtroom without the judge there. Like requests for admissions and interrogatories, depositions allow you to figure out what a person is going to say when they're asked certain questions in the courtroom. I can't recall now. I'm like 99% sure you can subject witnesses that are not a party to the action to depositions. I don't see why you wouldn't be able to. I'm pretty sure if somebody has been subpoenaed to appear in court, and obviously they've not been sued, they're just some other person that you need to testify. Pretty sure you can subject them to a deposition. Just to see what they're going to say and see if they're going to be useful at all. The deposition is, as I mentioned, it's very informal. It's just you and your lawyer, if you have one, and them and their lawyer there, if they have one, to help with objections. Because sometimes in the deposition you'll be asked questions that are objectable, and the lawyer can say, object to that, don't answer it, and then you can just move on to the next question. Anyway, just like requests for admissions and interrogatories, the answers that you get from the person being deposed will help you understand what they're going to, you're going to know in advance what they're going to say when you go to court. And the presentation in the courtroom will be a lot more precise when you've subjected all of the people to depositions and figured out, exactly how they're going to answer certain questions. It'll also tell you if you're going to need a different witness to testify in a different way, sort of oppose them. It'll also tell you if you need to get certain documentation that you didn't think you might need before, because you're getting an answer that you didn't expect you were going to get. And obviously, your opponent is going to be doing all of the same things. Everything you and your witness says is going to help your opponent narrow down what direction they're going to need to go into, when it goes to court. And I think I really didn't mention this in the previous videos. I may do a separate video on this, but obviously, it's not just dealing with court. It also can help to end the case before it even gets to court. Depositions, requests for admissions, interrogatories, and requests for production of documents, sometimes through this process, you're able to actually get the case thrown out or a summary judgment without even ending up going to trial, just because, you got lucky and they admitted to certain things, they answered interrogatories a certain way, they said something in a deposition, and it just basically there's no comparison for the court to do. They don't have to weigh the testimony of witnesses and weigh the evidence because certain things were admitted to. And anyway, sometimes these discovery tools actually end a case before it becomes a case, but not before it goes to trial. So hopefully, having seen these 4 videos, people have a better understanding as to what the point of it all is, because I know it can be extremely expensive for attorneys to do all of this for you. Hopefully this helps people understand the purpose behind all of it, because really, if you don't do this, you just end up going into court and having no idea what's going to get said, and it's kind of a crapshoot. I know that this is how small claims cases are held, and it might seem like it's just good enough for everyone else, but it really isn't. With extremely complex legal cases, you just can't do that. You have to iron out what's going to be coming up well before the actual court date, so that there's some order to that presentation, and it's not just total chaos and ambush. Hopefully people can respect the process a little bit better, understanding it and the purpose behind it. So with that, I'll go ahead and end this video, and I'll see you guys next time.